Shall we start, Mr. Rowan, or should we wait a few more minutes?
Are you ready, Dr. Zhao?
I think he said yes, but he was muted.
Okay. Okay, I think the webinar can start now. Please, Haekal.
Okay. Thank you very much, Mr. Wawan. And on behalf of all the committees, in collaboration with the Universitas Gadjah Mada, Law School of Universitas Gadjah Mada, with the University of Southampton, we're all gathered here. It is a pleasure to have Professor Zhao among us to discuss a very quite recent news actually that hit the media. I think it's not foreign to anyone if everyone has access to at least social media. I think all of us might have known of what the incident was. And today we're gathered here to have about around 20-30 minutes to hear the presentation and materials from our honored speaker, Mr. Zhao. And after that, we would have a discussion session of about 15-20 minutes. So please prepare any questions that you might have in mind regarding to the topic today. But without further ado, today we will have a discussion regarding the Ever Given and the Suez Canal.
Recording in progress.
Maritime issues do we have? So I think when faced with a situation where a huge tons and tons of ships blocking one of the prestigious, one of the valuable canals where it acts as a route to commerce, there's lots of issues to be aware of, not only from the business side, not only from the commercial side, but also from the maritime aspects also that needs to be discussed. And today we are honored to have Professor Zhao from the University of Southampton. Professor Zhao studied law in Dalian Maritime University, China, and he received his LL.M. in Maritime Law from University of Southampton and his PhD from the University of Hong Kong. He was also a visiting scholar of the United Nations Commission on International Trade Law in 2008, and an academic visitor of City Law School of City University London in 2014, and a senior researcher fellow of the Maritime Law Center of the Faculty of Law at the National University of Singapore from 2016 and 2019. He is also a member of the China Maritime Law Association and Hong Kong Maritime Law Association. So it's just such a pleasure to have an expert on this topic. So please, I highly advise and suggest the students to make good use of this opportunity to propose or forward any questions that you might have in mind regarding this topic. Without further ado, I'd like to hand over the floor to Professor Zhao. Please, Professor Zhao, time is yours. Thank you.
Thank you, Haekal, for a nice introduction. It's my great pleasure to say something from perspective of maritime law on the extent to the vessel. Oops. Yes. First of all, the topic is the Ever Given blocking in Suez Canal. What maritime law issues do we have? Before we start, you may see the QR score, left corner, bottom corner. Then, students, you may scan the code and enter your details in the form so that University of Southampton can send you more information. All right, let me start from the vessel herself. I could just briefly introduce the background of the incident of the vessel. The vessel Ever Given blocked the Suez Canal in March this year. It was anticipated that could be blocking for 1 month, but later, and luckily could be solved so quickly within 6 days, but it still caused a huge problem, although the salvage was very successful just for 6 days. We know from perspective of the economics, the finance, it caused a huge problem. But for law, we're thinking how to solve the legal problem. Now, before we say the legal issue, let's say the background information about the incident. First of all, this is the vessel ever given was a huge container ship. It is so huge, almost 300 meters, and it is one of the largest container ship in the world. And on the other hand, the Suez Canal is one of the most important and busy trading routes. You can see the picture on the right-hand bottom. When the canal was blocked by ever given, how many vessels was blocked outside the canal? So that means the busy route of Suez Canal. Now the background incident is the vessel blocked the canal, and immediately after the incident, the maritime salvage operation started. That's maritime salvage. I'll explain the detail of the salvage later. And finally, the vessel was refloated and freed on 29th March, just 6 days. When the canal was cleared, the service from for the go through in the canal was resumed on the same day, but the vessel ever given was free, but not all other vessels. When all the other vessels waiting outside the canal went through the canal, and finally the canal was cleared on 3rd April. Okay, let's see the vessel's information. You may think that's a simple instance, it's just a vessel and the canal. But if you see the ship's information, you may find that is actually a complicated issue. At least for law, we have to think many complicated legal issues because of the ship's information. First, the ownership. The vessel ever given is owned by a Japanese firm. So the ship owner is a Japanese company. But the owner does not operate the vessel by himself. The vessel chartered, third point, time chartered the vessel to a Taiwan company, shipping company, Evergreen Marine. But the ship owner does not register the vessel in Japan or Taiwan. The ship is registered in Taiwan. Okay, the vessel is time chartered to the Taiwan company, Evergreen Marine, but the vessel is technically managed by a German ship management company. The Japanese company as owner does not provide crews working under the vessel. All crews are Indian nations. And the ship can cargo from China to Rotterdam when it ran grounded in Suez Canal. The ship's information shows us the international characteristics of maritime. Now you see, it's only one vessel, but behind the one vessel, we can see so many international elements, from the ship owner to the ship registration, to the ship manager, to the ship time charterer, and the crews and the cargoes. None of them belong to one single nation. I explained the legal background from the information of the vessel to show you we may consider the legal issues from different law. For example, why the ship's registration is important. We know everything, including the car or vessel, will be registered. When the vessel is registered in a place, the law of the place will apply to, for example, registration, sale of the vessel, or or demise charge of the vessel. So the place of registration will apply to disputes about the ownership or possessionship of the vessel. Okay, that's for the property law. Ship owner, they build the vessel or they purchase the vessel, but they will not rent the vessel by themselves. Ship owner will, like third paragraph, time charter the vessel to the evergreen marine. I'll explain time charter later, but that's a contract for employment of the vessel, for commercial use of the vessel, time charter. But time charterer will not operate the vessel. The vessel will be operated by a professional manager. In this case, is German ship manager. Okay, so think about the vessel. If there's any problem of the ownership, then there will be a concern of the Japanese owner. If there's any technical problem of the management of the vessel, that could be responsibility of the ship manager. If there's a matter of the commercial use of the vessel, that will be concern of the time charterer. So when the incident happened, we will say, first of all, who involved in the incident and what's the basis for their relationship. For example, if it's about the management of the vessel, what's management? For example, crews. Who provides crews? Could it be the ship owner? Could it be the manager? That depends on the basis between the relationship, which is a management contract between the Japanese ship owner and the German manager. If it is the manager's responsibility to provide the crews working on the vessel, and if it is negligence of crews in navigation which caused blocking Suez Canal, resulting in the liability of the ship owner, the ship manager may be liable for such loss. Next, if it is a dispute about commercial use of the vessel, for example, the vessel was blocked in Suez Canal for 6 days, which means the time charterer cannot use a vessel for 6 days because the vessel is blocked there. That's the loss of the time charterer. The charterer may claim against the ship owner depending on the relationship between the time charterer and ship owner, which is based on the contract called time charter. Okay, that's not all, because the vessels are blocked in the canal. Also, the cargo is blocked on board the vessel. Now think about the position from the cargo interests. When we say cargo interest, which means the cargo owner or the seller or buyer, the parties from sales contract. When the vessel is blocked, when the delivery was delayed, there may be cargo claim. Say the cargo is from China to the European countries. So this must be Chinese seller, the European buyer, who may have dispute with the ship. Now this becomes a little bit more complicated because we say more contract basis. Seller, Chinese seller, European buyers, ship owner, time charter, and the ship manager, who shall be responsible for the cargo damage or the negligence of crews. So all parties may involve in the whole disputes. Sorry, if I can make this sentence so complicated and you cannot follow me, but don't worry, I will explain the issues one by one. I hope that's not to give you the pressure to think about maritime law, but just raise your interest in maritime law. So first of all, I explain the information and discuss the possibility of the dispute between the parties, because that's the incident that happened just this year. And for maritime disputes, you may know the result of the dispute after a few years. So we just anticipate the possibility of the dispute. And even after a few years, the disputes may be resolved without the publishment of the judgment, because arbitration, which is confidential to the parties. Okay. Next is the also important information, which is financial information. Excuse me. Why financial information is important? Because we will think about the possible damage and the possible cover for the damage. First of all, the ship is insured in Japanese market because Japanese ship owner. And second, they evergreens protection indemnity liability insurance covered by Mutual UK P&I Club. Now we have two new information to most of you, if you don't have an idea about maritime law. Insurance or marine insurance. Typically we have three kinds of marine insurance according to the subject of the insurance. One is the hull insurance, hull and machinery insurance. That insurance for the vessel. Vessel's insurance is called hull and machinery insurance. Second is cargo's insurance. Oh. Naughty boy. Can anyone do something?
The fuck up. You fucking bitch.
Who is this? Wait.
Shall I? Okay. If I can.
Aryan, right?
Yeah.
Is that you?
If I. Okay, I stop sharing and try again. Probably, yes, that will disappear. That's what I can do. Okay, let me share again.
So sorry, but this Dr. Zhao, I think there is someone else from outside UGM.
Okay, it's fine. That's okay. I know it's online talk sometimes. It's out of control. Yeah, no problem. Okay, let's continue. The financial information. That's a matter of the money. The money is important for two things. First, where the money is from. And second, where money goes. Where it's from means who will take the responsibility for paying money, where the money can be earned from. In most of cases, you may think that dispute between the ship owner and the cargo owner, there could be cargo owner paying the ship owner, or ship owner paying the cargo owner. Yes, but that's not the end. For example, if the ship owner's liability, that would be the question, where the money from ship owner. It could be, but there's a common practice of maritime industry, that all ship owners buy insurance. Okay, then the ship owner will have the insurance for the vessel. When the ship causes damage, when the damage caused to the ship, then the ship owner, like in this case, you can say that's damage to the vessel here. And for the damage to the vessel, the insurer will pay the damage to the vessel. A second, the P&I clause, which is for the party's liability. For example, the ship owner's liability or charter's liability. That for person's liability, which may not be covered by insurance company, but by P&I clause here, P&I clause. That is protection and indemnity clause. That is a mutual organization between the ship owners, because traditionally the party's liability is not covered by house insurance, because house insurance is for damage to the vessel. But for ship owner, they may have the damage to the vessel, but on the other hand, they may have liability to other parties. So P&I club or P&I carbon is kind of the insurance, mutual insurance between ship owners to cover ship owner or charter's liability. Okay. Third is cargo insurance. That's insurance for loss or damage to the cargo. Okay, that's the cargo insurance. Third kind of insurance. We don't have information about the cargo damage. We assume if this damaged the cargo because the vessel was delayed, then the cargo insurer will pay damage. But that's not all. When the insurer pays the damage to the insured, the insurer may claim against the third liable person. For example, if the cargo damage, the cargo insurer paid the damage to the cargo owner, then the cargo insurer found that is the ship owner's liability who caused the damage. Then the cargo insurer may claim against the ship owner as third party to the insurance contract. Okay, that's where the money is from, and then continue to say where the money goes. Because the vessel blocked the canal, at least just a few days later, one day before, the vessel was afraid, at almost 400 ships were queuing to pass through the canal. That's prevented and anticipated about almost $9 billion of trade. All disputes about the money, that's where the money would go. Now, we have the general background of the incident. We have the information about the vessel. We have the financial idea about the money, about dispute. Now it's time to think about the legal issues. Now, I list some illegal issues because we cannot cover all maritime law issues from one case. But this is a good case to have a look at some maritime law issues from this case. Not case, incident. First of all, the legal issue is jurisdiction, which means which court has jurisdiction, which court can exercise jurisdiction over the dispute. Well, of course, that depends on the dispute at first. For example, if the dispute between the ship owner and the charterer, well, let's see the contract, the time charter. If the time charter has jurisdiction of an English court, then the English court has jurisdiction. That's jurisdiction based on contract. But normally they have arbitration clause. That means that there will be jurisdiction of arbitral tribunal, not court. Second, there could be disputes of tort. For example, the Egyptian Port Authority, the government, they suffered the damage when the vessel blocked the canal, which caused damage to the canal and financial loss. But there's no contract for such kind of damage. They just have a contract for using the canal, but no contract for damage. So that is the liability in tort. Okay, so the jurisdiction of the tort dispute will be the place, will be the jurisdiction of the court of the place where the tort activity happened. That should be Egyptian court. A court may have jurisdiction when a vessel is arrested. For example, if the cargo damaged, cargo owner may want to claim against the ship owner for the cargo damage. They have choice to claim against the ship owner in the country, in the court of the country of the ship owner. For example, the ship owner is a Japanese company, cargo owner can go to Japan to claim against the ship owner. But on the other hand, then, for example, the European buyers, they found the goods damaged, but they may not want to go to Japan. So it's because of the far distance, they just want to claim in their own countries. One way is to arrest the vessel. For example, English buyer, they may arrest the vessel of the ship owner when the vessel arrived in English water. Then, by arrest the vessel, English court has jurisdiction. So that's jurisdiction by a ship arrest. But even English court has jurisdiction by arrest the vessel. English court may feel or may be satisfied that a Japanese court is more appropriate than English court to deal with the dispute. Then the English court may stay proceedings and ask the party to go to Japanese court for dispute resolution. This is called the forum non-convenience. Forum non-convenience. Okay, those are matters of the jurisdiction. Next, applicable law. What law apply to the disputes? Again, that depends on what dispute they have. If this dispute between the ship owner and the time charterer for time charter party dispute, when we see the contract, time charter first. Normally, there's applicable law or governing law in the contract, which it could be English law, if it's London arbitration, or a New York state law, if it's a New York arbitration. So the party may choose the law for the dispute. Then that chosen law will be governing law. The principle is we call the party autonomy. If the dispute in tort, that means no choice for law by parties, then court will examine all the relevant factors to find the most real connection. For example, the vessel arrested by English court for the liability in tort, but the court, well, the English court has jurisdiction, but English court may not apply English law because they will find for the liability in tort occurred in Suez Canal, the most real connection between the dispute and the liability is Egypt. So Egyptian law may apply to the tort liability. Okay, that's general background information about the legal issue, jurisdiction, and applicable law. Next is for the maritime issues. Carriage. For carriage, we mainly have three kinds of contract: voyage charter, time charter, and the bill of lading. Voyage charter, the relevant issue is the late time and demurrage. Late time is time for loading and discharge operation. For example, 3 days for loading, 3 days for discharge, or 6 days for loading and discharge in total. That's the free time for the voyage charterer to use the vessel. Time voyage charter only pay the freight. But after the free time, then using the vessel for loading or discharge operation is not free. the charter should pay the money we call the demurrage. And the demurrage is paid once it happened, always happened. That means if that is 6 days for loading and discharge, and loading operation 6 days expired, then demurrage happened, demurrage started. That's a liquidated damage for the use of the vessel after late time. That means when the vessel left Chinese port, the demurrage happened. And when the vessel was blocked in Suez Canal for 6 days, 6 days will be counted for demurrage. That'll be huge damage from the charter to the ship owner. Next, time charter. Time charter is contract for using the vessel for a period of time. Charter pay hire, the money is called hire. Pay hire to the ship owner for using the vessel. But sometime when the vessel is not in full working position because of agreed the event, then charter will not pay hire. We call it off hire, which means the charter will not pay for the using the vessel within for the 6 days when the vessel was blocked in Suez Canal, off hire. Next interesting issue is choice of a route. That may not be concerned about the choice of route for ever given in Suez Canal, but that could be concerned of the vessel outside the canal. They are blocked outside the canal. They cannot go through the Suez Canal. So the ship owner may want to change the route. So that's a question about choice of route. Who has the right to choose the route? Time charterer or ship owner? All depends on negotiation. Normally, time charterer has right to give instruction for the choice of the route. If Suez Canal was blocked, then they may, if it is anticipated 1 month blocking, they may choose other route for the carriage. The loss of a carriage is a bill of lading, which is a cargo claim. The cargo may be damaged because of the delay. Well, here's not physical damage. It could have been damage delay. Everyone from the cargo interest may claim against ship owner or charter for the cargo damage. They may have, well, the party may include the Chinese seller or European buyer who may claim against the ship owner or time charterer or voyage charterers. I mean, cargo interest claim against the ship interest. The next is Maritime Law, which includes the salvage operation. We know the salvage, that is Dutch salvage salvage company sell the vessel. It's not free service. The ship owner will pay the salvage charge to the seller. For the salvage cost, the ship owner will not pay all, or they will pay all, but they will request the contribution from the cargo owners. That's contribution, that's a share of the salvage payment between cargo owner and the ship owner, is called general average. The reason behind general average is the salvage is not only for the interest of the ship owner, but also for cargo owner. Because when the vessel was salved, both the vessel and the cargo were salved. So the cargo owner have interest in the salvage. So the cargo owner will contribute to the salvage payment. You may find, wow, the ship owner may have a huge liability to the port authority, to the salvage company, to the cargo owner. For such huge liability, the ship owner may not be able to pay all. Now, the last issue is a limitation for liability in Maritime Law. There are special rules for Maritime Law, of Maritime Law. Ship owner, according to international convention or domestic law, may is that may apply for limitation of liability as a ship owner, which means according to law, they calculate the limit of the liability and they put equivalent money in the court. We call it the limitation fund. That all claimants should register in the court for the claim. That's all money the ship owner will pay in the fund. Nobody else can claim more than the fund. That's a limitation of liability of the ship owner. That's a special rules for the maritime law. Last but not least is the insurance. As I explained just now, how insurance for cargo damage to the vessel. Cargo insurance, the cargo insurer will pay damage to the cargo, and the P&I cover, P&I clubs will provide cover for ship owner to cover ship owner's liability to third party. For example, ship owner's liability to the canal authority for the damage. That's the liability issues. Okay, that's all the relevant legal issues of the maritime law from the instance of the ever given blocking the Suez Canal. And there is a limited time, we can't cover everything, but just for the interest of the maritime law, because that's the one of the reputable and famous program in Southampton. Besides the issues I discussed, we have taught modules including law and charter party, flagging, marine insurance, admiralty law, and the relevant commercial law issues, for example, sale for goods, trade finance, ship finance, etc., etc. Those are the taught module. And also for degree study, we require dissertation. We have good look of the career after graduation. People can work in international law firm or the for the claim in ship owner, or cargo owner, or insurance broker. Besides study, we also have enjoyed a good life in Southampton. Okay, that's all what I I plan to talk today. So, any questions? Welcome. Thank you.
Thank you very much, Professor Zhao, for the wonderful presentation and materials. And just while we await questions from the students, I'd just like to give just a quick recap from what Professor Zhao have presented to us and given to us. Well, overall, there's lots and lots of there's quite some aspects that need to be considered here in the incident of the Ever Given in Suez Canal, whether it be in the aspect of the ship's information, the international elements that it has from the ownership and the registration, the chartering party, the technical management, the crew, and then the route, which comes from all sorts of different countries, and also the legal issues that it carries along, which covers the issues of jurisdiction, applicable law, the carriage, the aspect of the admiralty law, particularly, I think, which I find personally interesting with regards to the law of the salvage and also the insurance. So there's quite many aspects that can be can become the initiation of our discussion today. So please, for all the participants who has questions or inquiries regarding our topic today, you can either state your question in the chat, or you can raise a hand, and then we'll allow you to ask your questions directly. So please.
Excuse me, Haekal.
Yeah.
So I have another meeting at 10 o'clock, and I hope I can few minutes of break. So
okay.
I'll limit the Q&A for 5 minutes.
Yeah. Okay. Sure. Okay. So maybe we'll open for like 2-3 questions the most. Okay. Anyone?
Or you probably have a more general question. I know as maritime law probably is too special to most of the students at the first time. So could there be any general question for law study in Southampton or even Southampton City, or a general question?
Okay. Okay, sure. I'll start off one of the questions, I guess, just to ignite the interest of the students. So from this incident, Professor Zhao, we've learned, or we've seen that the canal, the Suez Canal, is very small. It's very strategic, but it only allows for one ship at a time. And I think due to one reason, technical reason, due to one or more technical reasons, the incident occurred, despite all the parties that were responsible for the incident. But from this, do you think that there might be a possibility that another similar incident would occur in the canal? And if that happens, what sort of things, what measures can we learn from the current situation that that is experienced by the Ever Given? I think that's my question, Rizal. Yeah.
Well, that's the very good question, but it's also the very challenging question, because that's not a question of for a law professionals. Because we Southampton has a business school. We have a colleague from business school. We discussed the same incident, and I asked a question to them, like your question, because the concern to the business is the supply chain. When it's blocked, have a selection, all the cargoes, the vessels are blocked outside. I have to say, unless Egypt authority widen the canal, it's hard to avoid blocking again next time. After incident, probably ship owner and the crews take it as more serious than before. But it is believed after a long period of time, the crews may feel relaxed, don't worry much about the canal navigation. Then, yes, I don't think the incident will occur frequently, but well, technically, when it first of all, for the mast and the crews working on board the vessel, they should be careful in navigation in the canal. Second, the pilots in from the Egyptian Port Authority, they should give the good service to in particular for the big vessels go through the canal. I guess the legal term we call due diligence. The general word means be careful in navigation in the canal. And for more technical, we say depend on the vessel, depend on the weather, depend on the all circumstances. But the navigation is complicated. Yes, so you said we forget the liability. So yes, that no matter how much the ship owner will pay, finally, navigation is still technical, you see. So I think the only solution is due diligence. Be careful about navigation.
Okay, great. Thank you, Professor Zhao. I think we have one here from one of the students from Pyronisa. So she asked, how do we actually measure the general average, Professor Zhao?
Oh, we actually spent one lecture, 2 hours for this question. There's a professional person we call adjudicator for assessment of the general average based on normally, if English law apply, York Antwerp rules. That's international rules, York Antwerp rules. The rules have different versions. So if you can Google the York Antwerp rules, you will see the detailed rules for how to calculate what money will be calculated for general average. And the general rules is we will calculate yes, the cost of the not the cost. The general rules is that the cost for the benefit of both ship owner and the cargo. For specific item, which item can be included, which is not considered, it's a little bit complicated. So you just remember York Antwerp rules, then you can see the details for calculation general average.
Okay, great. I think there's quite a few lectures materials out there too on how to get the general average, but I think that's the general idea from Professor Zhao. Okay, we have one here from Liang Puji. So what kind of things of issues for bordering between crime and trade beyond the UNCLOS, beyond the United Convention on the Law of the Sea? Yeah, so he's asking, are there any specialization? Because Liang Puji is a student in the master's in law program. So what aspect that can be picked up from this topic, Professor Zhao?
First of all, I'm a maritime lawyer. I'm not a criminal law, trade lawyer. I can't answer the question, but we do have colleagues in Southampton because we have a module international trade law, we have the module for law of the sea, we have expert in this fields. But I can't answer this question. Sorry for that.
Okay. But if, well, on that note, if you are interested, Gilang, or any other student for continuing or having their master's degree for a joint degree, there is a scholarship being offered by the University of Southampton. So all the participants can please check out the link that I'm going to distribute right now. And there's a £10,000 opportunity for one student to be granted the scholarship. And I think one more question, is that okay, Professor Zhao? I think we have one more here. Yeah. The question is from Audrey. That this case is pretty complex with many states involved. Then can we say that negotiation takes a bigger role to choose in terms of choosing the applicable law to settle? And does accident like this occur often, especially due to this complexity?
Yes, negotiation or settlement is very, very important for shipping industry or maritime law. But that does not mean we don't need the legal knowledge. The maritime law study is also important for negotiation, but negotiation is a good solution. So that's why we talk about the court litigation. Before that, we suggested arbitration. Before that, we suggest mediation. It's kind of similar to the negotiation. And I can tell you, it's not uncommon that maritime disputes may be settled before parties go to the court, go to the arbitrate, because it's not free. It's cost expensive to have arbitration or litigation. Yes, negotiation is very important between the parties, including the insurers. They settle the dispute before they decide to go to the court. Right. Yes, negotiation is important.
So by court, do you mean is it often for parties to resort to the International Tribunal on the Law of the Sea, the ITWAS that get provided by UNCLOS?
Sorry, can I say again?
The International Tribunal of the Sea, is it often for parties to resort to that?
No. That is for public law, for public disputes, not for private.
So private will depend on the parties in whichever ways they want to settle.
Yes, normally they negotiate and they go to arbitration and go to court, domestic court for like commercial disputes. Right.
Okay, great. Duly noted, Professor Zhao. Should the discussion session with suffice, Professor Zhao? Is it okay if we conclude now?
Yeah.
Yes. Okay. Before I conclude, do you have any concluding remarks, Professor Zhao?
No, thank you. Yes. By the way, welcome to Southampton. And if you have any question, you can scan the code below and enter the information. We can send more information. And if you have any request, a question, you can send back to us. We are happy to answer the questions later.
Great. Thank you very much, Professor Zhao. So students, scan the link and check out the scholarship link also. And with that, I think there's lots of legal aspects particularly that we can learn from today's discussion. And hopefully it could be a fruitful one, either for our studies or future research. And I highly encourage for everyone here to further deepen our analysis and also our interest in maritime law, because after all, Indonesian is an archipelagic state. Yeah, we have lots and lots of shipping routes. And I think it'll be a great opportunity either for studies or for practical fields, in the future. And with that, I'd like to conclude today's session. Thank you very much again. It's an honor to have Professor Zhao, and we do apologize for all the shortcomings that has occurred during this meeting. Hopefully, we can continue our connection and our relations in the future for whatever events that might be beneficial to both UGM and also Southampton. So thank you very much, Professor Zhao. It's an honor. I close. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Thank you.
Thank you,
Thank you, Dr. Zhao.
Thank you very much, Professor Zhao.
Thank you. Bye.
Bye.
Okay, thank you, Mr. Wawan.
Sama-sama, Mas Haekal.
Okay. You didn't leave me, Mas.
Ya,
Yeah.